Hello, Environmental Policy 1 students. I'm back for week 7, which is entitled Understanding Basic Environmental Law Design. This is when we start to get into a little bit more of technical related issues in terms of being able to identify and to interpret environmental law, regulations, and of course compliance, promotion, and enforcement measures of for regulations. Now, the important thing to keep in mind in this section of the course is that this expertise comes from a lot of practice. Once I've done this lecture, you've read my lecture notes, and you've gotten into this week's reading material, it's important for you to pull up the Canadian Environmental Protection Act or pull up the Fisheries Act perhaps, and one or two others, and look at these acts and try to understand the relevant parts that I'm going to talk to you about in this lecture. Now, there are three major components of understanding environmental law, and that is understanding or identifying the source law from which the environmental legislation or law derives its authority, and that's an important issue. Defining the authorities in the law themselves. What does the law allow the government to do? And what authorities are provided in the law for action, okay? And then defining what compliance, promotion, and enforcement aspects are allowed under the law. That's the third key ingredient for understanding how these laws are implemented. And as a regulatory affairs officer, as opposed to being a legislative drafter, let's say, you're mainly concerned with defining the authorities of the law and the compliance, promotion, and enforcement requirements of the law. Now let's deal with item 1, which is the source law from which environmental laws derive their authority. In Canada, it's a complex issue because, of course, our Constitution, the BNA Act of 1867, and the revision in 1982 and the patriation of the Constitution, the environment was never clearly described as a division of authority between federal and provincial governments. So environmental authorities are drawn from a number of other constitutional authorities, which is the supreme law of the land, of course, from other constitutional authorities found in the Constitution. And those constitutional authorities that can direct towards a mandate for developing environmental law reside both in federal division of powers and in provincial division of powers. And in the municipalities where they derive their authority because they're entities of provincial governments, they also develop environmental law and regulation. So we have three levels of government that develop law and regulation. And it's important to understand that they all derive their authority from the principal law of the land, which is, of course, or the predominant law of the land, which is the Constitution. Now, the Constitution is more than just a piece of paper in Canada. The Constitution is comprised of, originally the BNA Act, but also a bunch of common law and legal decisions that have been taken that all comprised, a Supreme Court judge would tell you, is our Constitution. In 1982, that became somewhat streamlined, but the BNA Act is still relevant. That is the division of powers between the governments. Common law is still relevant, but we also added the Charter of Rights and Freedoms, which also can come into play in environmental issues. So, I don't expect you to become constitutional political scientists, experts, or lawyers in this course, but I do expect you to understand that any environmental law or legislation must derive its authority from the Constitution or some other supreme law, or predominant or dominant law, higher order law. Now, defining authorities in a law is an exercise that you just have to go through and read the laws and try to understand their component features, and they all have standard features. I mean, there's always going to be some form of purpose and objective statement. It's really important to understand that because that's where the initial sort of qualitative scope of the law is laid out. Then there will be more scope and coverage related information, okay? And you can find this list in my lecture notes for the week. Then there will be a section on key legal principles that are applicable within the law. And it's important to understand those because those can be quite important in how the rest of the act is interpreted, okay? Then terms and expressions or terms and definitions will have to be there again because the rest of the law is interpreted according to the definition of those terms, okay, and those expressions. Public and private sector responsibilities under the law will be in there somewhere. Now, remember I told you in one of the previous lectures that, and including last week, that any environmental regime will always determine a division of responsibility between public and private actors. No government can enforce all aspects of an environmental law. And as I told you before, if you rely on enforcement to implement your environmental legislation, you've probably already lost. Compliance, it has to be done. Viable enforcement has to be there, because without it, there's no reason for people to see what the consequences of are on non-compliance. But ideally, you want to have voluntary compliance, and that's why compliance promotion is so important. And then there will be a section in there that will designate the primary administrative authority for the law. I mean, who is it? One department, two departments shared? How is that described in the law? The scope and type of policy instruments that can be used under the law. Now, why that's important is that in the previous historical periods, environmental legislation used to be drafted in such a way where the regulatory or technical requirements were right in the law. Now, we all know how fast the world changes, how fast technology changes, and so on. So if that's the case, every time you had to change a regulation or change something important in the law, the whole law had to be changed. And you can imagine how long that would take. So what the world has done in Canada as well is shifted to what we call enabling legislation or framework legislation, which sets out macro authorities and all the things that I've just mentioned to you before, and creates powers where regulations can be developed under the law, but they're separate from the law. There's separate documentation. There's a separate process for regulation development. And then when you have to change a regulation, you just change the regulation. You don't necessarily need to change the whole law. In fact, the whole process has even gone further. Now you find regulations that also don't want to be changed every time there's a technical issue. So regulations will often reference guidance documents, which are even easier to change if a piece of guidance applicable to a regulation needs to be changed. See? So that's the way that works. Then there will be a section of a law, the delegated authorities under the law. Is there a self-regulatory organization? Does the law reference a private standards organization like the Canadian Standards Association? Does it reference a professional body of site remediators or something like that? So look for that as well in any law. Then it comes to the inspection authorities, the compliance promotion and legal aspects of a law. Very important for regulators, like your environmental policy people who are dealing with regulation will have to be aware of. Then there'll be record keeping and reporting requirements. All laws have some kind of a reporting requirement. Why? Because, as I said, government cannot do all the implementation. A lot of the implementation actors will be private, and they have to report back to government, and government also reports out to the public. Enforcement authorities. This is where you get down to the legal nitty-gritty. What happens if you really have a bad actor that isn't complying and enforcement warning letters are not adhered to? What authorities are there under the Act to enforce through legal means? Confidentiality requirements. In a lot of cases, industry needs to report back to government and confidential information that's commercial, private, technological advances, things like that. So there has to be confidentiality requirements in the law. Then there's, of course, any legal procedure in a liberal democratic society where the rule of law prevails. There needs to be an appeal process under enforcement actions. Okay, so look for what those appeal processes are actually about. Now, in my lecture notes for the week, I also talk about key points that most key principles, that most environmental legislation will have in them. And those will be concepts like prevention. And we already talked about the importance of prevention over the costliness of mitigation. Precaution, the precautionary principle. Polluter pays, right to know, knowledge-based management. By that I mean that almost all environmental legislation relies heavily on scientific information. The role of science in law and regulation in the environment is really paramount. And transparency, that's public awareness. public communication, transparency with respect to compliance, promotion, and enforcement, performance under the law in terms of improved environmental quality, those kinds of things need to be made transparent. How much that is in fact done is itself a political issue, but there's almost in every environmental law there will be a component in there on that. Now, with respect to item 3 on compliance, promotion, and enforcement rules of procedure, these are typically documents that draw their authorities from the law and what the law says about enforcement and compliance that I noted to you just now. But they tend to be separate documents that lay out what will be done by the government to promote compliance under the Act, and what will be done by government in its enforcement actions in the event of non-compliance. Now, why is that important? Well, because any enforcement action under the rule of law requires that legal procedure be followed, right? I mean, you can't just pick up a guy off the street, arrest him, throw him in jail, right? You have to have a trail of evidence. You have to have a scope of authority of that law. You have to have a whole bunch of other things. How evidence is gathered, how evidence is stored, what's the chain of evidence, all of those issues come into play. So a compliance, promotion, and enforcement rules of procedure document, and you can find that for CEPA, Canadian Environmental Protection Act, will have key terms and concepts in it, just like the law, how enterprises can receive information as to how to comply with the law. It will set out random and targeted inspections to be carried out under the law to make sure that in general everybody's complying with the regulations under the law, or at least they're intimidated by the fact that they could be inspected if they aren't. And that's the aspect of enforcement that's so important to back up compliance, promotion, and enforcement. The scope of authorities of inspectors under the law will be clearly laid out. What legal procedures will be followed must be clearly laid out. Chain of evidence requirements, as I just said, rights of enterprises with respect to confidentiality will be reinforced in there at a sort of practical implementation level. Types of sanctions available to discourage non-compliance and due processes will be clearly laid out. And all of those things are critical because you can have a law, you can have regulations that are really well drafted, but if at the enforcement stage these things are not clearly laid out and followed precisely, then things will simply be thrown out of court. Or the industry will know that the enforcement isn't going to be sustainable, and that will put downward pressure on voluntary compliance. Okay? So keep these things in mind. Read my lecture notes. Start to go through, type in CEPA, Canadian Environmental Protection Act. Look it through, see if you can find those components in CEPA that I lay out in my lecture notes and I just talked about. Then CEPA and rules of procedure for compliance, promotion, and enforcement are also there. It's in your readings, but you can just Google it and it'll come up. And take a look at what those look like and see if you can find the components I flag in my lecture notes in that document as well. Now, one final point I want to make on this is that any industry, regardless of what business it's in, will have that life cycle that I told you about before. Let's say they're building cell phones. They'll have the cell phone design. They'll have inputs into that cell phone manufacturer. They'll have the manufacturing process itself. They'll have transportation-related impacts. They'll have use-related impacts and final disposal-related impacts. Now, one of the things that good environment professionals need to understand is that the environmental regulations, the environmental laws and regulations that an industry will encounter or a business will encounter can fluctuate across those life cycle stages, right? That's why you have to think about law in a life cycle sense if you're working for a company as well. Like, let's say the VP Environment comes to you and says, okay, I'm new to this business. I'm here as a completely new to environment guy. I'm really just a business bureaucrat assigned to manage this beast, and I need a briefing on what laws are applicable to us. Really, I haven't got a clue. So basically, what you would then do is say, well, actually, at our input stage, these are the 2 or 3 kind of laws and related regulations that are most important. At our production stage, actually it shifts to we have air emissions. We have things that have to be dealt with respect to heavy metals, with respect to water runoff, and things like that. At the final disposal, it could be some of the ones you just talked about, but it could be 1 or 2 additional again. So just one company doesn't just have one list of one part of the life cycle. It's only these regulations and that's it for everything. No, at different life cycle stages of the product or process that the company goes by, there can be different environmental impacts on environmental media and on human health. And you can be assured that somewhere at the federal, provincial, or municipal level, there is a law and there is a regulation that deals with that. Okay? So a good environmental expert will not just start with law. They'll say, okay, what is the life cycle of our product? Where do we have environmental impacts at each stages of this life cycle? And then they would say, okay, well, we use a lot of water here and we all have water emissions. So boom, I'm going to the Fisheries Act and I'm going to SEPA because I know the regulations under those will be applicable. So I need to find out what those are, plug them in. Okay, at the disposal stage, I know we have hazardous materials. So I know I got to go to SEPA and I got to go to the regulations related to hazardous waste. Okay, that's the way to approach it. Approach it first through life cycle and understand the environmental impacts on environmental media, air, water, land. Okay, and you need to then say, okay, where are our major impacts here? Okay, then I know that we're going to have issues with water here. So I got to go find out what all the applicable regs are for us here. Okay, I mean, for sure we're going to have air issues here. So, we need to go find out what that is, what those regulations are. And that's the way to approach it. And when you write things up, approach it that way. Your briefing note is, dear sir or dear ma'am, the blah, blah, blah. You asked for a briefing note on what pieces of environmental legislation and related regulations apply to our company. I'm going to give it to you at the various stages of the life cycle of our product. So then you say, design and related inputs, boom, 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 anything that's applicable. Including the transportation of those inputs into your process. Then manufacturing, where are our major areas of impact and therefore what regulations apply. Use, our materials are currently, our products now are currently energy hungry. We need to be working on, climate change rules are going to be coming in. We're going to need to be working on energy reduction, energy efficiency. Here are the types of measures that would be applicable to that. Waste disposal, same thing. Okay, that's the way to think about it. You don't dive into the law, you dive into the life cycle and the impacts on the environment and what laws are likely to be applicable, because you may not know them all. You might have to go fishing. Well, I know the federal ones, but what are the provinces doing on this? Oh my God, municipalities too, what are they doing on this? And that's how you talk about law and regulation. Okay, so on that I'll leave you. Enjoy the readings, enjoy the discussion for the week, and